Have you ever found a judgment was made against you, but you were never served? If that's happened to you, I'm sure you're wondering, is there any way that this can be corrected? The answer is possibly yes. It all depends. But the first thing you'll need to do is find out the procedures, the process of service in your area. What is the appropriate way that it's done? For a federal court, it would be the Federal Rules of Civil Procedure number 4. If it's a state court, you're going to have to find out what that court's rules are. Once you have a good idea of what is required, then you need to get your hands on a copy of that judgment, the complaint, and the affidavit that is returned to the court after service of process has been made. Now, on this affidavit, you will have the date that it was delivered. Sometimes they put the actual time, the location, and that they delivered it directly to you, or if it was not to you and it was left at your home or business, who they left it with. Sometimes they'll just put a description of the person. But that information in itself is going to let you know if you have a good chance of getting this judgment thrown out. How would you do that? Well, if it says on the affidavit that they delivered it to you at 123 Main Street, but you live at 321 Main Street, you would have to produce evidence. You just can't say I don't live there. You would produce evidence in the form of a lease agreement or a HUD statement that shows that they took it to the wrong address. Another way that you could disprove it would be if you were out of town or in the hospital or out of the country. If you had the receipts from your hotel room or your airfare, the hospital records, these are the kinds of things that you can use to disprove service occurred. Now, after you've looked at the rules, what's on that affidavit and what evidence, this is the point where you really have to be honest with yourself. Are you going to be able to overcome the service that they said occurred? If so, then you would file what is called a motion to set aside or a motion to vacate the judgment. That means to cancel it, throw it away, because you never had the opportunity to defend yourself because you were never served. If you are granted that motion to set aside or vacate, then anything that was awarded before, any liens, any garnishments, all of that disappears.